yes, we've had dissents on both of our reports. We are, just as a quick background, we are a 5-member board. We are bipartisan, which is why, and part why we have dissents, because we have two Republicans and 3 Democrats. But I think in some ways it's healthy to have a diverse views as part of our debates and discussion. We don't always agree with each other, but we all, as with here, I think we're very civil, and I think it in some ways sharpens our views and lets the public also, because we are very transparent about where we agree and where we don't agree, to let people know where we're coming from. I would also add that we're independent, and by that I mean, and we can have a discussion of that, is that we are free to disagree with the President of the United States when we are part of the executive branch, but we're also independent in the sense that we can express our own views. And a perfect example of that is the 215 program, where we took the position, among other things, that the program was not legally authorized. The President disagreed with that. He was of the view that on policy grounds, the program should be discontinued, but not on legal grounds. But we were free to vote on our board and come to the conclusion with regard to legality. I guess I would also point out that I suspect that the European Parliament, the European Commission, our Congress, most courts aren't always unanimous in everything they do. And so I don't think it's surprising that a group would, a number of people would have differing views. But again, we try to be as transparent as possible about them.
Would you like to ask a question of Jan or Paul?
Well, sure. Where's your PCLAB? And that is, I think you make a fair point, Paul, that and Jan too, that the United States obviously is a larger collector of information and has stood for important democratic and civil values. So I'm not saying that we shouldn't have an important role, but you know, these are sophisticated European countries as well that have been around for some time, that have intelligence communities that are maybe not quite as large, but are certainly sophisticated. What work is being done on the European side to address some of the privacy and civil liberties programs that are raised by Germany's programs and England's programs and other programs as well?
So then I take the privilege to be somehow responding very self-critical, because although I'm also critical towards your opportunity to really independently assess the national security information processing in the US, there's not such an equivalent on the level of the European Union, because the European Union has no opportunity to oversee or regulate anything in national security in the field of how national security is done by the member states. But there should be, and that means for politicians in Europe quite a huge challenge, because they need to change their legal framework to get it done, to get common rules on national security. And I have to say that in some member states, including my own in Germany, the scrutiny of national security agencies' work is, I mean, far away from perfect, to put it very nice, because there's a huge lack of judicial oversight on intelligence work, and there's also still a huge lack on parliamentary oversight and on public oversight in general, which I would see as being the core of what we should learn out of this revelation of Edward Snowden, because public scrutiny cannot be replaced. But I think that this is something which both sides of the Atlantic, US and EU, and the rest of the world can learn out of it. We need public scrutiny, but that means getting away from the secrecy. So we need to see the privacy and data protection debate together with the transparency debate of governance, and especially also of law enforcement, and also including intelligence work. And that needs to be done, and only if that exists, two things will happen. One, individuals will be even at least able to get redress on their surveillance. Because if I would go to court as an individual right now, I would never succeed to get anything out of it, because I cannot prove that I'm subject to a certain program, although the revelations by Snowden are indicating that clearly. But I need some proofs, and that's perhaps not sufficient in front of the courts. At least it hasn't been until now. It could change in the future. And secondly, only then we will be able to assess what are reasonable and proportionate manners. And that is what I would like to think as a politician I need to put on the table, because necessity, what is necessity of data processing taking place? And necessity and proportionality tests, at least in my judicial background, means you always need to have a look if there is a way to get something done with a lower infringement, a lower level of infringement into our individual, into our fundamental or human rights. And I don't see that being happening until now. And I have to say, and that's the ball I play back, in your work, are you really doing that? Looking into less intrusive manners, like saying, couldn't it also be possible to get national security work done without collecting massively personal data of persons who are not at all related to any risk, any certain group which is inside of what you are looking into, or any region? I mean, I really sometimes question why is the GCHQ, as you're referring also to others, looking at me as a German for a national threat to the UK. I mean, this sounds very awkward also to a European, which thought, Europe was a project of peace and common values, and not of looking at each other like being a threat to our own national security.
Let me just, if I could quickly take the ball back, and then Paul can respond. But I think what you suggested about less intrusive alternatives is really what we did in the 2015 report, which is to say the government is collecting massive amounts of information. It really only needs a small percentage of that. Go to the phone company to get that small percentage and stop collecting the mass amounts of information. We also, in the 702 report, and the upstream process is very complex, but what we recommended is that there be some more technological work done to separate out the various components of upstream, to then allow for a policy judgment to be made, perhaps to not collect all of those things. So I think that's an important approach that I think we've already taken, which is where the government could be collecting less and be effective, and some would argue actually going to the providers is more effective. But yet collecting less information, it should do that. But sorry.
No, I think what you just said is, I think, one of the key issues. Namely, we need to take an even harder look in the future at the effectiveness, the alleged effectiveness of all these different methods. Do they really deliver the intelligence which allegedly then avoids death? And there, the Court of Justice had so serious doubts that it annulled the data retention directive for similar reasons which you outlined. We have financed research into this, and the Professor Scheinin from the Florence European University Institute has just finalized a huge project. We have put millions into this, called Survey, on which he reported, by the way, this week on the Just Security blog in the US. And he also came to the conclusion, like you, that the untargeted, and like the Court of Justice, that the untargeted mass collection of data is basically ineffective. And the interesting thing about this study, which the Commission financed, is that it compares the effectiveness of different instruments of intelligence collection, right, starting from mass collection, right, to targeted following of people, old-type spying, and so on. So I think there we have, possibilities to go in the direction which also the President outlined in his speech in PPD 28. I think, let's say, on the policy level, there is a consensus that we have to move away from mass collection to more targeted operations, which then also include safeguards. that is, I think, a trend on both sides of the Atlantic. Now, to come back to your question, which I would say is a legitimate question, but is also provocation. I think if you look overall at the fundamental rights compliance of an intelligence complex, you have to look at three things. A, the substantive rules guiding the activities of this complex. B, the procedural safeguards. And C, the size and the overall resources, and compare the resourcing of the checks and balances with it. What we see in America is huge resources for intelligence activity, small resources. If one looks at the resources of the P Club, you have criticized this yourself a number of times for counter checking. I would also say that in comparison to the enormous people power of the intelligence complex, even what Congress can do in law or what the judges can do, it's not sufficient. But one can discuss this. Then let's look at the substantive law. The shocking thing for me personally was that all the things which Snowden put on the table are legal. There are no substantive limitations. It all is legal. The mass collection is completely legal. And that is not the case in many member states in Europe. Of course, in 28 member states, we have very divergent picture. Probably in the UK, the laws are like in the United States, some people say even worse. But you have other countries which do not allow a blanco mass collection of everything on the internet. You have other countries who say you can only collect for specific purposes, for a limited time period. You must limit the collection in geography, and you must limit it to a certain percentage of the flow. And that is a substantive limitation, which is important because it reflects fundamental rights. On oversight, it is true that we don't have the P Club, but here I would diverge a little bit from Jan, and maybe just because I don't do it politically, but I do it as a lawyer. It is not so that there is no judicial oversight of intelligence activities in Europe. I would just like to give you a number of examples. There is very clear jurisprudence in Europe by constitutional courts, but also the European Court of Human Rights in Strasbourg and the Court of Justice on the limitations on spying. For example, there is a commonly recognized principle that ways of communication must be free from surveillance. Very simple principle. Where in America we hear, well, there's no expectation of privacy here and there. Well, in Europe, I think you can trace through many constitutional courts in member states, but also the jurisprudence of the European Court of Human Rights, the general principle that ways of communication by principle must be free from surveillance. There can, of course, be exceptions based on law and proportionality, but the principle is no surveillance on communication ways. And why? Because this, and you said it yourself, this is essential for freedom, for democracy, for the societies we want to live in. It is also not right to say, and this is my last word, that the European Union has nothing to say when it comes to national security. It is true that the treaties say national security is a matter of member states, and this is an exception to the rules of integration we have in the treaty. And the European Court of Justice has said on this exception it has to be interpreted narrowly, and this is jurisprudence relating to the United Kingdom. If a member state invokes this exception and says, you stay out, this is national security, then the member state must demonstrate to the court that what it intends to do is necessary and proportional for national security. So what does this mean? This means that the European Commission, as guardian of the law, and guardian of the treaty, has the power to look into proportionality of activities of national security services, and in fact, we have started to send letters to member states and inquire. And in fine, it would be the Court of Justice which decides whether what's happening here is necessary and proportional or not. And at the end, I would like to share Jan Albrecht again, and I do this